because the consequence of not keeping these environmental requirements at the forefront is fines and having to invest then in further expenses for efforts to address agency violation notices. Welcome to A Higher Law, a cannabis podcast from the Dykema law firm. I'm your host, Grant Gilezan. For more episodes, you can find us at dykemapodcast.com, youtube.com/Dykema Law, or by searching A Higher Law wherever you get your podcasts. On today's episode, we'll be focusing on air requirements with potential applicability to operations in the cannabis industry, particularly cannabis processing facilities. Joining me is my guest, Tony Percha, who is a principal at GZA GeoEnvironmental, Inc. Tony leads their air practice at the firm, and I have enjoyed working with Tony on air-related issues for over 3 decades. Before getting into how to best determine and comply with any applicable air emission requirements, Tony, I think it would be helpful for you to generally overview how air emissions are regulated among federal, state, and local authorities.
Sure. Thanks, Grant. Well, to begin with, many years ago under the Clean Air Act, EPA was required to establish certain standards, which are termed National Ambient Air Quality Standards, that applied to what EPA terms criteria pollutants. Initially, there were 6 criteria pollutants, primarily ozone, carbon monoxide, nitrogen oxides, sulfur dioxide, particulate matter, and lead. The Clean Air Act does not regulate odors, and greenhouse gases were recently considered a pseudo-regulated pollutant. Since the initial criteria pollutants were developed, the particulate matter standards have been broken down by size, so now there are regulations for PM 2.5 and 10. Basically, EPA was tasked with developing those standards and then designating areas within the country as attaining or not attaining those standards. And EPA then developed programs that would implement state-level requirement, and the states are to develop a general plan to attain and maintain those standards in all areas of the country, as well as a specific plan to attain the standards for each area designated as not attaining those standards. The plans at the state level are referred to as state implementation plans, or SIP. One of the key programs designed to achieve compliance with the National Ambient Air Quality Standards was a program referred to as the New Source Review Program, which is a pre-construction review program that is ultimately a permitting process for new and modified stationary sources, not mobile sources. At the federal level, the New Source Review Program applies to what are considered major stationary sources or major modification. But states also implement permit programs for sources that are considered minor sources. Individual emission sources are responsible for determining the status of their facilities and the needs for permits pursuant to both the state and federal regulations.
Yeah, as I think Tony has made abundantly clear, there obviously is a very comprehensive regulatory scheme across our country, but there is not an automatic applicability to all operations that happen to have air emissions. Rather, as Tony concluded, and it's an important point, the source of potential air emissions has the responsibility to determine whether any emission requirements are applicable to it before it begins operations. So on that note, Tony, let me next ask you, how would a business planning to run a cannabis processing facility make such an advanced decision when planning to start up its business?
Well, Grant, a cannabis processing facility could have potential emissions of volatile organic compounds, as well as maybe fuel combustion related emissions, things like small boilers or emergency engines, that type of thing, to help support the processing facility. Some growing operations can emit VOCs, are known as terpenes from the plants themselves. But there are processing operations that will utilize solvents for extraction purposes, which can result in VOC emissions. And by extraction, I mean extracting those chemicals that are important to the industry from the plants themselves. So to determine what air permitting obligations the source would have, an initial step would be to try to characterize those emissions based upon a term that is consistent within the air quality world. We refer to it as potential to emit, or PTE. PTE is typically based on a year-round operation, 24 hours a day, 365 days per year at the maximum capacity of equipment. And it's typically results in a ton per year calculation, which is then compared to the various permitting thresholds to determine what type of permit would be required, if at all. And that's typically a first step to evaluate your emissions and compare it to various thresholds that apply at the state and federal level.
So it's very important to note that not only before you begin operations, but before you even start constructing the facility, you need to undertake the evaluation that Tony just outlined. And so if in doing that evaluation, that PTE, or potential to emit evaluation, demonstrates that the operation would have applicable air emission requirements, then Tony, what must be done before the cannabis processing facility can begin its efforts to construct and prepare to operate?
So if a PTE analysis, or in some cases, even based upon actual emissions, projected actual emissions, if that evaluation suggests that the facility may be subject to air quality regulations, key step is to determine what approvals must be obtained from the air quality regulatory agencies prior to beginning construction. For the most part, facilities must obtain an air permit from the appropriate agency prior to beginning construction, let alone starting operation. These approvals can take different forms, though, depending upon the specific of a state's or a county's air permit program. Certain states may have registrations for general permits, small sources of emissions. Other states may have emission-based exemptions from permit requirements, while some states may require a minor source permit similar to larger sources. It should be noted, however, that a typical cannabis processing facility using today's technology would be expected to have emission levels well below major source threshold, but that can change over time as technology changes. So the key is make sure you know what the requirements are at the state level if you're a minor source, and make sure that you understand whether construction can begin prior to obtaining the permit. And then also make sure you know what the steps are required for the actual operation of it.
Well, it certainly sounds like there are many options and potential pathways for a cannabis processing facility to pursue. But I think one key question or issue for them to manage in preparing a plan to operate would be to have a sense of how much time is it going to take to go down these pathways. I know that the timing will be dependent on the requirements and the permit needs associated with those requirements, which then can also vary depending on the state that the facility would be operating in. But I was wondering, Tony, if you can shed any general perspectives on the typical time needed to prepare and submit such a permit, and then after that to receive agency approval.
That's a tricky question, Grant, but I can shed some light on what I typically experience and what I think might be the case here. So generally, if a permit application is required, development of a complete application would be the initial step. That can take 1 to several months, depending upon the level of complexity of the state program that you're attempting to deal with. Things like, are there modeling requirements for certain pollutants within a state? Some states have those requirements, some states don't. And the availability of the specific information regarding the planned project. Oftentimes, designs are ongoing and details of the project may not be available, uh, and can basically lengthen the time it takes to develop a complete application. Once that application is complete, the time for review by the agency varies quite a bit depending upon the type of application, whether it's a registration, a general permit, or a minor source permit, as we mentioned before. But I would say that the typical time frame for a simple permit application that is complete by an agency is around 3 months for small emission sources. That can be much longer depending upon the completeness of the application, the permit review engineer's knowledge. That's a very person-specific issue. And the workload at the agency, as well as the applicant's ability to respond to the inquiries from the agency. Some states may require a public comment period, for example, if there's a controversial source. Some states require public comment periods for everyone. And that typically happens after a draft permit is prepared, so the public has a chance to review that draft permit. There can be things like notifications in newspapers or libraries, and those periods typically last from 30 to 60 days. One thing to note, though, is some states may allow for a construction waiver, and there can also be situations where you can pay a fee for an expedited permit, but all those are very state-specific.
And by a construction waiver, you mean there may be the opportunity, depending on the state program, to get permission to begin construction of the facility, but not begin operations of the facility. Is that
That's
right?
right.
Yeah.
That's typical. The waiver to construct is a term, for example, in Michigan, but there's limited applicability of those waivers in most cases.
Yeah, and I think it might be a good point here to take a more global view for a minute of where the country is at with even allowing non-medical use of cannabis, in that it appears we're still less than half the states allowing for such uses and such facilities to process cannabis, and still at the federal level there is a legality issue in terms of any use of cannabis. I mentioned this because as we're talking about the various pathways, primarily at the state level, that there will be variations not only among the state air programs, but also, of course, that there are still more than half the states in the country that wouldn't even permit this. So there is certainly a handful of states now that are getting traction in the area of the cannabis industry, and in particularly siting of cannabis processing operations. But it still is a newly developing industry, and one for which the regulatory programs in the 22 odd states that now allow it are still in a very early stage of processing and setting programs for permit requirements related to the cannabis industry. And there are a number of states that have still yet to come online. On the federal side, even though there is a question that if there is a need, because of and it would be anticipated to be in a very rare occurrence that you would have emissions from a processing facility that would exceed the federal threshold trigger. But assuming that you would, in your site plan, exceed that trigger when you do your potential to emit evaluation, and assuming that there isn't an outright legality problem, you would be subject, as would any other emission source, to federal permitting requirements. And perhaps, Tony, on that note, could you just drive the audience through what is that threshold that you would be hitting that may take you into the federal program beyond state requirements?
Sure. So I think I mentioned previously that major sources, only major sources, require a federal permit, and that the threshold for major sources are significantly higher than, like you said, the emissions typically associated with a cannabis processing facility. However, it's important to understand that those thresholds are somewhat dependent upon the attainment status of an area. For example, the ozone attainment status, for which VOCs and nitrogen oxides are precursor. Those thresholds can vary and are typically lower in non-attainment areas, which makes sense. But if you were to exceed one of those thresholds, whether in an attainment area or a non-attainment area, the real issue is that the evaluations associated with pursuing that resource review permit, the complexity of the evaluation increases greatly, much more burdensome, and the amount of time that it takes to obtain a permit can increase exponentially. And obviously, in certain situations, there will be public comment periods like we talked about previously. But one of the other complicating factors is, for example, in non-attainment areas, if you did trigger the need for a federal permit, you may be subject to providing offsetting emission reduction, which can be a challenge to find in those non-attainment. But for smaller sources whose potential emissions happen to be higher just based upon the way you would calculate potential emissions, applicants can propose to use controls to reduce potential emission, or they can take on limits in a permit that would reduce the potential emissions to below major source threshold. So there are options available to applicants that might have a higher PTE just based upon the way you calculate.
Yeah, that's very helpful to know. I think that point in terms of potential emit, as perhaps as unusual as it may be for a cannabis processing facility, that should a larger facility see that it's bumping up against that federal threshold, whether it's to avoid, namely the federal permitting requirements, which, as Tony described, involve much more cost and effort and time, which can further challenge than site planning and construction goals. But also will completely avoid the legality issues as well of pulling in federal oversight of a facility that right now does not have federal permission to operate because of the nature of the business. And that is a complex area. But assuming, Tony, you navigate the field successfully for obtaining the permits, then how often must the permits be renewed, if at all? And could you also describe what are the typical compliance monitoring in reporting requirements under the permits so that the operating facility knows that, well, it's achieved the great goal of having a permit, of building the facility, operating the facility, but essentially then what are they living under and for how long?
Sure. So, two things need to be considered here, Grant. One is that for minor source permit, many states issue what we often refer to as construction permits or installation permits. They all have their own term of art in terms of what they refer to ordinance permits. But typically, those construction permits do not need to be renewed, while other states may issue operating permits subsequent to construction. But if you are subject to the federal new source review program, in other words, if your PTE is high enough that you would trigger those regulations, you may be subject to what's referred to as the federal Title V operating permit program. That program applies to major sources, but the definition of major source under that program is somewhat different than the definition under the new source review program. That complicates matters, obviously, but generally, this Title V program is an operating permit that would essentially combine all of your requirements into one permit. It would include things like record keeping, monitoring, testing, and reporting. So if you're a major source under that program, you typically have 12 months from the startup of your operation to apply for a permit under that Title V operating permit program. And there are certain shields that can be available when you make application for that Title V permit. You have what's considered an application shield. And then the state will typically issue that Title V permit after that. So minor sources typically do not have renewal periods, but the Title V permit program requires that you renew your permit every 5 years. So that's typical. And similar to the new source review program, you can take on limits to avoid being a Title V source based upon the definition of another source under the Federal Tax Code.
And Tony, from your experience, because I know from mine, which is usually after the agency has visited or otherwise reviewed operations, that the source of emissions is notified of certain non-compliance with permit requirements and with the air regulations. Uh, and I know that there is reporting that goes on during the year, but is it also customary from your experience that the agencies administering air permits will actually come out to the facility and do inspections or on-site evaluations of the operations?
Yeah, that is very typical. However, one of the impediments to that is staff shortages and resource constraints at the agencies. And there's probably going to be many, many cannabis processing facilities. So the sheer number of these facilities likely something that would impact what the inspection schedule is. But I would say that you could expect probably no more than an annual inspection. And typically what that consists of is the agency coming on site. It would involve a visual assessment of the operations, generally in comparison to the permit terms and conditions if you have one, or if you're required to keep records to meet an exemption from the permit requirement. And these inspections may seek to identify sources that maybe are not correctly permitted or inconsistencies with things like exhaust characteristics. Michigan, for example, will include stack parameters in their permits. So they may look for things that are relatively easy to identify, or record keeping, like you suggested, in comparison permit requirements.
The thrust of the agency compliance assessment really does translate then for the operating facility in a business financial management uh, decision. And that decision should always favor compliance with permit requirements, because the consequence of not keeping these environmental requirements at the forefront, even though they are, let's say, a cost, it's not a revenue side, of the business, but the consequence of not maintaining compliance are fines and having to invest then in further expenses for efforts to address agency violation notices. These notices of violations can often lead to the development of then an additional instrument beyond a permit called a consent order, which then also mandate additional compliance requirements and penalties for not meeting those requirements. So there is a goal of compliance that really is an incentive to avoid having a second layer of requirements laid over the operating facility by virtue of what is called a consent order, which is almost like a contract, an enforceable contract that is developed by the regulator and the regulated source, most often the state and the business, and under which then there are additional permit requirements or additional requirements to those already set forth in the permit. Uh, so, in even severe situations, not often occurring, but the agency also has as at its disposal other tools which can have very severe business consequences for non-compliance with permit requirements. And one of those tools is actually cease and desist order, where operations would need to stop until all enforcement actions have been successfully resolved. And that could lead to absolutely catastrophic business expenses. Another tool, again, rarely used, but under the current setting where there is very active, very stringent adherence to environmental programs at state and federal levels, and particularly with smaller businesses. So I would note this for the cannabis processing industry is one of more potential sensitivity, is that beyond targeting the business itself, the agency, if there are principal individuals making decisions for the business, also has at its disposal very broad provisions in the environmental or in the air laws to pursue individual responsibility or individual liability against a person. And if conduct is rising to a knowing violation level, even pursuing potentially criminal liability against individuals and the business enterprise. The Clean Air Act that Tony referenced at the beginning and its state counterparts have a very broad, uh, very robust enforcement tools available to the agency. And so they are all very much strong incentives to maintain compliance with your air permit requirements at all times possible. Uh, and I'll also, while we're going through somewhat the parade of potential horribles that we all would like to avoid, Tony also mentioned at the beginning too that while there is extensive federal and state air requirement and air regulatory schemes, they really don't get into odors. But that's not to say that odors, which can very well be and have been an issue that cannabis processing facilities have had to manage, that doesn't mean that odors then are not something that could be subject to other forms of regulation. They just would not fall under the Clean Air Act and state counterpart schemes. And the odor issue then really is one that more regularly defaults to local authorities because it gets down to very traditional doctrines of use and enjoyment of neighboring properties and anything that is threatening or impairing such use and enjoyment. Uh, the nuisance complaints, can be addressed by the permitting agency, but more often will only involve public safety officers, local police, um, that would be then addressing those issues separate from any compliance with a permit. I raise this because there can be an odor issue that nevertheless needs additional management that is otherwise unaddressed under the permit itself. So in other words, you can be complying with all your permit requirements, but that's not a shield, it's not a guard against odor issues if they happen to be presenting as a problem. So having gone through all of the potential compliance or non-compliance issues and how to best work that into your daily business operations, I'd like to turn it over to you, Tony, for one last segment here on your thoughts about what operating cannabis processing facilities may consider incorporating into their business plans to help help them avoid having any problems down the line.
Sure, Grant. I think your mention of this odor issue is an important one. I know that there are some states that within their state air quality regulations, they do have nuisance provisions um, that I've seen be used with respect to odor related issues. And we know that cannabis processing, actually cannabis growing, was potential for significant odors with terpene, um, the materials that are used in those processes. So I think that's a really important point that you made. But with respect to moving forward and trying to be able to mitigate enforcement issues, non-compliance situations, basically speaking, the main way to address that is to devote the appropriate resources to the management of environmental compliance. For those companies that have the internal resources, many rely on things like environmental management systems, which can include internal auditing of the various processes and plans that are contained within your environmental management system to make sure that those plans are being appropriately implemented. Other companies may rely on intensive compliance audit on a periodic basis by third parties. That's often something we see. Others may rely on their available audit immunity programs, and these programs can provide immunity from enforcement if, through a noticed compliance audit, a company identifies and self-discloses non-compliance issues. There's limited applicability for those programs, but devoting resources to management of compliance seems to be a good thing to do all the way around in terms of being able to maintain compliance and catching potential non-compliance issues.
Yeah, I think there lies a very important business management philosophy, and that is that if you can count on the agency paying attention to you, most likely showing up at least once a year, let's say, to your facility to do a wellness check, looking at your paperwork, looking at your emissions data, and seeing how things are really coming together, then the way that the law is stacked up is that if there are certain imperfections, and no operation can ever be always perfect, that are first noted by the inspector or otherwise first raised by the agency, then at that point forward, you really are excluded from any opportunity, no matter how diligently you respond to it, from having any excuse for the problem that has occurred and for limiting the amount of any penalty or action that will be needed to be taken in response to it. You can have a very robust response to such a notice of a violation, but you're already working behind in what I call the reactive mode. In the proactive mode that Tony was just outlining for you, the incentive to the business is that if you are looking at yourself and you are first flagging these issues, which are inevitable to occur from time to time, then the way that the law provides recourse is to allow you to self disclose, allows you to implement your own self corrective action program. And in so doing, the law also gives provisions to be saying no penalty at all should be assessed against you, or a much more significantly reduced penalty, if any, should be issued against you, and that there won't be any further additional compliance actions that the agency will insist upon affirmatively, but rather they will look to the program that you instituted on your own, which, because of your own design, is always the more efficient and more effective approach to go. So to keep you out of that reactive mode and to keep you into the proactive mode, there is a strong leaning that for whether it's mature operations in decades long industries or newly emerging industries, that there always be some component, no matter how small, no matter how large your operation is, that there's always some internal compliance assessment mechanisms that are built into your business plan for the facility, so that you can eliminate, if not minimize, any financial impacts of the environmental regulations on your day-to-day operations going forward. I hope that the shared exchange that Tony and I have afforded to you has helped you understand the role that air regulations play in your planning for siting, constructing, and operating cannabis processing facilities. Tony and I would certainly welcome you reaching out to us with any questions you may have, and we'd be happy to help you navigate your processing facility planning process as smoothly as possible. But that's it for us today, and we do end here thanking you very much for taking the time to listen to some of the stories and some of the experiences and perspectives that Tony and I have had in helping people deal with their air issues over a number of years. As always, you can find us at dykemapodcast.com, youtube.com/Dykema Law, or by searching a higher law whenever you get or wherever you get your podcasts. My name is Grant Gilezan, and on behalf of myself and Tony Percha, we thank you very much for your time listening to us today, and I look forward to seeing you next time on another edition of A Higher Law.